Welcome to the Concubinato in Uruguay podcast. Today we're diving into something really relevant for, well, anyone building a life or partnership here in Uruguay. We're talking about the union concubinaria. Think of this as your essential guide to understanding the whole legal side of unmarried relationships here.
It's a very practical topic, definitely, because, lots of countries recognize unmarried couples in some way, but Uruguay, it has this really specific set of rules, procedures, all laid out in the law.
Right.
And getting a handle on these details, it really can give you a proper sense of clarity, maybe some security for your relationship and, your future here.
Absolutely. And that's exactly what this deep dive is all about. We've pulled together the key sources.
Yeah.
We're looking at the foundational law, Ley 18.246, that actually defines the union, but also official guides on taxes, IRPF, IAS stuff from the PPS, on Social Security, and even some analysis comparing Uruguay to how other places handle this.
And our mission really is to unpack what the law actually says. Translate that, legal jargon into practical insights. What are the rights, the obligations? What does it mean for you, the listener?
Yeah.
We want to show how understanding this framework, it really empowers you to make informed decisions.
Okay, let's get into it then. What exactly is a Uruguayan union concubinaria, according to that main law, Ley 18.246?
Right. So the law defines it fundamentally as a de facto situation. It's about two people. And critically, this applies regardless of their sex identity, sexual orientation. That's quite clear.
Okay.
The key things are living together, exclusivity, so a singular relationship, stability, permanence, and it has to be an effective sort of sexual relationship. And obviously, they can't be married to each other.
It's definitely more than just like roommates.
Oh, absolutely. It implies a committed partnership.
And for this partnership to actually have legal teeth under this specific law, there's that crucial time element, isn't there?
That's the bedrock for most of the effects under Ley 18.246, yes. You need uninterrupted cohabitation, living together for at least 5 years.
5 years.
That 5-year mark, that's the trigger point for a lot of the legal rights and obligations we're going to talk about.
This is a really, really important distinction that sources make.
Yeah.
Just living together for 5 years or even longer doesn't automatically mean your union is formally recognized under this law.
Exactly. That's spot on. Formal recognition is a separate step. It's voluntary. You don't have to do it.
But it sounds valuable.
Incredibly valuable, yeah, for establishing clear legal standing. And the way you get it is through a judicial process. You actually have to go before a family judge.
Go to court? Really?
Yes, it's a court proceeding. It can be started by the couple themselves, the concubinos. They can file together or one can file alone. But what's quite interesting, the sources point out, is that even after one or both partners have died, someone else with an interest, like say an heir, they can actually initiate this process too. They just have to legally justify why they need the union declared.
Wow, okay. And for this court process, you definitely need a lawyer, I assume.
Oh, absolutely. You'd want professional help. Navigating a judicial process like this, yeah, it typically needs a lawyer's expertise.
So what's the judge actually deciding in this process?
Good question. The main goals are twofold. First, to legally pin down the exact date the union started. That's vital for calculating that 5-year minimum and other things.
Right.
And second, to identify any assets, any goods that were acquired in common through joint effort or funds during the time of the union.
And once a judge issues this declaration, this recognition,
Right.
Where does it get recorded?
Okay, so once the court declares it, it becomes official. It's registered in the Registro Nacional de Actos Personales. There's a specific section there just for unionist concubinarias.
Oh, okay.
So it creates a public legal record of your recognized union.
That makes sense. Establishes it formally.
Right.
So, okay, let's say a couple goes through this. The union is legally recognized by a judge. What are the main effects? What actually changes legally?
Right. This is where the framework really starts to bite, starts to provide structure. One of the biggest things is the creation of what the law calls a sociedad de bienes.
Society of goods.
Yeah, basically a community of property or goods. The recognized union automatically gives rise to this, and it functions a lot like the property system in a marriage, the sociedad conyugal, unless the partners have specifically agreed on a different way to manage their assets.
So it pools assets acquired during the union.
That's the principle, yes, under certain rules. And a really key point here, creating this new sociedad de bienes automatically dissolves any previous property regimes. So if either partner was previously married or in another recognized concubinato with its own property system, this new one replaces it.
Okay, that's a big one. What else happens right away when the union is recognized?
Well, the law also says that the same kinds of contractual prohibitions that apply between married spouses then also apply between the recognized concubinos.
Like what, for example?
So things like rules that might prevent spouses from donating certain assets to each other or selling property between themselves under certain conditions, those same limitations would now apply to the concubinos.
Got it. And does this recognition affect financial ties from previous relationships, like alimony?
It absolutely can, yes. The sources highlight this. If you are receiving alimony, the pension alimenticia from a previous marriage, your right to keep getting that payment is lost once your concubinato is judicially recognized.
Interesting.
And even more interestingly, the law says this right to alimony can also be lost even if the union hasn't been formally recognized by a judge yet, if the union clearly meets the requirements for recognition, like the 5 years living together, and a person paying the alimony can actually prove this in court to stop the payments.
Wow, okay. So recognition means community property, contractual limits, potentially losing prior alimony. What about when the union ends? How does a recognized concubinato dissolve?
A recognized union can end in a few specific ways according to the law. One way is through a judicial sentence of dissolution. Either partner can ask the court for this, and they don't even need to give a specific reason or prove fault.
Just ask for it.
Basically, yes. The union also dissolves automatically, of course, if one of the partners dies, or thirdly, if one of them is legally declared absent, which is a specific legal status for someone who has disappeared.
And if it ends through that judicial dissolution, the court sorts out the practical stuff.
Exactly. When the judge issues the dissolution sentence, they address several crucial things. If the union hadn't been formally recognized before the split, the judge will determine the start date and identify the common property then. They also rule on issues related to children custody, child support, visitation rights, and importantly, the judge decides who gets to stay living in the family home.
Okay, that's practical. Now let's shift to a really critical area: inheritance, succession rights. What happens if the union ends because one partner passes away?
This is a really significant part of Ley 18.246. If a recognized concubinato dissolves due to death, the surviving partner, the concubino, gains succession rights. And the law states these rights are similar to those of a surviving spouse. It specifically points to Article 426 of the Civil Code, which deals with spousal inheritance.
Similar, but maybe not identical. We'll come back to that.
Yeah.
But what if the person who died was also still legally married to someone else, a surviving spouse and a surviving concubino?
Ah, yes, that's a key scenario the sources cover. It's quite specific. If you have both a surviving spouse from a prior marriage and a surviving concubino from the recognized union, they both essentially step into the shoes of where a sole surviving spouse would be. They concur, is the legal term.
So they share.
They share the inheritance portion that a single spouse would have received. And how they divide that portion between them is based on how many years each of them cohabited with the person who died. It's proportional to the time spent together.
That is very specific, a unique balancing act.
It is, and there's another specific right related to housing, isn't there?
Yes, the right of use and habitation. This applies to a surviving concubino who meets certain conditions. They need to be over 60, lack sufficient personal means for housing, and importantly, have lived with the deceased partner uninterruptedly for the last 10 years.
10 years for this specific right.
Correct. If they meet those criteria, they get a real right, a strong legal right, to use and live in the property that was owned by the deceased, or property that was common to the union. This right obviously affects what the other heirs receive, as the partner gets to stay in the home.
Mm-hmm. It prioritizes the surviving partner's housing security under those conditions.
So the law clearly gives significant rights, but you mentioned earlier, and the comparative sources noted, that the inheritance setup for concubines isn't exactly the same as for married spouses in every detail.
That's a crucial point of nuance, yes. While really important rights are granted, the legal structure for inheritance for concubines is defined by this specific law, Ley 18.246. It's not just a carbon copy of the entire marital inheritance system. It's similar in key ways, but tailored.
Okay, understood. Moving on from inheritance, let's look at Social Security, specifically the survivorship pension.
Right, the pensión de sobrevivencia, this is a vital benefit. It's potentially available from various Social Security institutions in Uruguay, the main one being BPS, the Banco de Previsión Social, but also others like the military, police, banking, notarial, and university professionals funds. They're cajas.
And what does a surviving concubino need to show to be eligible for this pension?
There are basically two main hurdles. First, The partner who passed away must have met a minimum requirement for service time credited in their Social Security record, though there's an exception. If the death happened during work or because of work, that minimum time isn't needed.
Okay.
Second, the concubinato itself, the relationship, must have lasted for at least 5 years before the death occurred.
5 years again?
Yes, but there's a key exception to this rule, too. That 5-year minimum duration for the relationship is waived if the couple had children in common.
Ah, okay. So having children together removes that 5-year requirement for the pension. Does the surviving partner's own income matter?
Yes, it can. The beneficiary's income level can definitely influence whether they have the right to receive the pension at all, and also the amount they receive. It's means tested to some extent.
And how long does the pension last? Is it always for life?
No, not always. The duration typically depends on the age of the surviving partner at the time the other partner died.
How does that work?
If the beneficiary is 40 years old or older when their partner dies, the pension is for life vitalitia. If they're between 30 and 39, the pension lasts for 5 years, and if they're under 30, it lasts for just 2 years.
So it varies quite a bit by age. Are there situations where it is lifetime, regardless of the beneficiary's age?
Yes. There are important exceptions where it's always vitalitia if the beneficiary is totally and absolutely unable to work due to incapacity, or if their family unit includes children who are also absolutely incapacitated for work and don't have enough means to support themselves. Also a specific one. If the deceased partner was in the military or police and died in service or because of service, the surviving concubino's pension is lifetime.
So the duration can change, and the pension amount or eligibility can also be adjusted later on.
Precisely. If your right to the pension or its amount is linked to your income level, it's not necessarily fixed forever. It can be suspended, changed, or even brought back later. If your financial situation significantly improves what the law calls misura de fortuna, the pension can be adjusted downwards or stopped.
And you have to report that.
Yes, the sources are very clear. Beneficiaries have a legal duty to declare any significant improvement in their finances. If you don't and they find out, the benefit stops, and you'll likely have to repay anything you received improperly.
Wow.
But the flip side is also true. If your financial situation gets worse later on and you then meet the economic criteria again, the pension can be started, adjusted upwards, or reinstated.
That covers a lot in the legal status and benefits side. It really shows how understanding this framework is just crucial if you're planning your life, your future here in Uruguay. Thinking about putting down roots, making investments, it's exciting, but you need this info. And speaking of possibilities and planning your future here, if you happen to be looking for properties or investment opportunities in Uruguay, we definitely recommend visiting realestate-uruguay.com. Okay, let's switch gears now. Taxes. How does having a recognized concubinato impact income tax? Specifically IRPF, that's the main income tax for physical persons.
Right, IRPF. It's an annual tax, it's personal, it's direct. It applies to the income of individuals who are resident here or sometimes non-residents earning Uruguayan income. And it famously splits income into 2 main types. Category 1 for capital income and Category 2 for work income.
Is there any special way recognized concubinos can file their taxes?
Yes, there's a potentially helpful option. If you have a judicially recognized concubinato and both partners are tax residents, you can choose to file your Category 2 income, that's the work income, jointly. This is called filing as a nucleo familiar or family nucleus.
Okay, filing jointly for work income. Are there strings attached? Limitations?
Yes, several key ones. It's only for Category 2 work income. It doesn't apply to capital gains or rental income, for example.
Right.
Also, neither partner can be a taxpayer of certain other business or specific taxes like RNR, IMIBA, or IS, which is the pension tax we'll get to next.
Okay.
And critically, you can't use this joint filing option in the actual year the union is legally created, nor in the year it dissolves. The choice to file jointly is made on your annual tax return, and once you choose it for a year, you're generally stuck with it for that year.
Got it. Okay, let's try and break down some key tax implications, maybe starting with Category I, capital income. How about, say, income from renting out property?
Okay, rental income. For IRPF, the tax is calculated on your gross rental income minus some specific deductions the law allows.
Such as?
Things like commissions paid to a property administrator plus the IVA on that commission, any legal or notary fees related to the rental contract plus their IVA, the property tax you paid, that's the contribution in mobiliaria, and the primary school tax, impuesto primaria. Also, if you're subletting, you can deduct the rent you pay for the property.
Is tax normally withheld on rental payments?
Often, yes. Certain entities act as retention agents. Registered real estate agencies in mobile areas usually do this, as do companies like IRAE taxpayers who rent rural land. They typically hold back 10.5% of the rent payment.
And the tax rate itself.
The standard rate on the taxable rental income after deductions is 12%. However, taxpayers often have the choice to just treat that 10.5% that was withheld or paid as an advance as their final tax payment. It simplifies things, avoids needing to file separately just for that.
Is there any way to be exempt if you only have a small amount of rental income?
Yes, there's a useful exemption. It's based on annual income thresholds linked to the BPC, that indexed unit. If your total gross rental income for the year is less than or equal to 40 BPC, that was about $247,080 for 2024, and all your other capital income combined is less than or equal to 3 BPC, around $18,531 for 2024, you can be exempt.
But you have to apply for it.
You do. You need to get authorization from the DGI, the tax authority, and part of that involves explicitly agreeing to lift banking secrecy so they can verify your income levels.
Okay, what about income from selling assets, like selling a house?
Right. That falls under incrementos patrimonialis asset increases, still in Category I. When you sell property or sign a promise to sell or assign that promise, any profit or gain is generally subject to IRPF.
How do you figure out the profit?
You usually have two ways. The real method is the sale price minus the original cost, updated for inflation, and minus any property transfer tax, ITP, that you, the seller, paid. Or for certain urban or suburban properties bought before July 1st, 2007, there's often a notional or presumed method. You just pay tax on 15% of the sale price, or the property's cadastral value if that's higher. And the notaries, the escribanos, they play a key role here. They are legally required to act as retention agents for these property sales. They withhold the tax at the time of the transaction.
Can that notary retention be the final tax?
Yes. Taxpayers generally have the option to consider the escribano's retention as the final payment for that specific gain. So no need for a separate filing for that income, usually.
Now, what about selling your own home, the place you actually live?
Ah, yes. There's a very important, very common exemption for selling your permanent home. This applies if the sale price is below a certain fairly high threshold, 1.2 million UI, indexed units, and you must reinvest at least half the money you get from the sale into buying or building a new permanent home within 12 months. The cost of the new home also has to be below a higher threshold, 1.8 million UI.
So if you sell your home and buy another one fairly quickly, you might be exempt.
Exactly. But here's the catch. The escribano handling the sale will still withhold the tax during the transaction, even if you intend to reinvest.
Ooh.
Yeah. Once you've actually reinvested and met the conditions, you then have to go to the DGI and request a tax credit or a refund for the tax that was withheld.
Okay, good to know. What about selling other things, not property, like movable assets?
For selling movable property, the general rule is the gain is taxed at 12%, but it's calculated on a presumed or notional gain of 20% of the sale price. However, there are exemptions based on UI thresholds here too. If the value of a single sale is below 30,000 UI, it's exempt. And even if individual sales are above that, if your total sales of such assets in the year are below 90,000 UI, they're also exempt. Above those limits, the income is taxed.
Phew. Okay, that's Category 1. Let's switch to Category 2, work income. How is that taxed?
Okay, Category 2 covers income from dependent work, being an employee, and independent work providing services yourself. The calculation differs slightly. For independent workers, the law generally allows a standard deduction of 30% from gross income to represent expenses. It's a fictional deduction, though notaries have slightly different rules related to their professional contributions.
And for employees?
For employees, it's based on their salary, bonuses, vacation pay, the aguinaldo, 13th month salary, things like that.
What deductions can you take against your work income?
First, you deduct your mandatory Social Security contributions. That's payments to BPS or your professional CAJA, your FONASA health contribution, the Fondo de Reconversion Laboral, and contributions to the Fondo de Solidaridad, if applicable. Those come off first.
Then what?
Then you have some key personal deductions. A big one is for dependent children or dependents declared legally incapable. For each dependent child, you can deduct an amount equivalent to 20 BBC per year. That amount doubles if the dependent has a certified incapacity.
And parents can decide how to use that deduction.
Yes, parents can choose. They can split it 50-50, or one parent can take the full 100% deduction. There's also a potentially large deduction for mortgage payments on your single permanent home. This applies if the original loan amount was under 1 million UI. The deduction itself is capped at 36 BPC per year.
And how do these deductions actually reduce your tax?
Good point. These personal deductions aren't subtracted directly from income. Instead, the value of the deduction is calculated at a specific tax rate, usually 14%, but it drops to 8% if your total nominal income for the year is over 180 BPC. That calculated value then reduces your final tax bill.
Okay, that's a bit different. Now, I've heard about a tax credit if you're renting your home.
Yes, that's another helpful one for Category 2 taxpayers. If you actually owe IRPF tax on your work income, you can claim a tax credit for the rent you pay on your permanent home.
What are the rules for that?
You need a formal, written rental contract for at least 1 year, and it must clearly identify the landlord. If you have that, you can claim a credit equal to 8% of the rent you paid during the year for 2024. You claim this credit when you file your annual tax return.
Does it reduce your tax directly?
Yes, it reduces the amount of IRPF Category 2 tax you owe. However, it can't generate a refund if the credit is more than your tax bill, and you can't carry forward any unused credit to the next year.
How does this tax usually get paid for employees? Through withholdings.
Exactly. For dependent workers, the employers are the primary retention agents. They calculate and withhold IRPF from your salary each month. They base this on your income and also on information you provide them, often using a form called Formulario 3100.
What's on that form?
That's where you declare things like your dependents for those deductions, if you have other income sources they need to know about, if you're eligible and choosing to use the family nucleus joint filing reduction with your recognized concubino. And crucially, you can also use this form to tell your employer if you want to opt out of monthly withholdings altogether.
You could just opt out.
Under specific conditions, yes. You can choose to be excluded from monthly IRPF withholdings if your total monthly income from dependent work is below a set limit. It was $61,400 for 2024, not counting aguinaldo and vacation pay. And you must have no income from independent work. And you can't be filing jointly as a family nucleus. If you meet all those, you can elect on Formulario 3100 for your employer not to withhold IRPF each month.
What happens then? Do you pay at the end of the year?
Potentially yes, or maybe not at all, if your total annual income remains below the non-taxable minimum. Your employer is also required to do an annual calculation, an adjust annual, usually in December, to try and finalize the tax for the year for each employee based on the full year's earnings and deductions.
So given all that, when does an individual actually need to file their own IRPF tax return, the declaration jurada?
You generally have to file a return if you have work income from more than one source, like 2 jobs or a job and some independent work, and your total annual income is over a certain threshold, 150,000 UI. Or you'd need to file if, for some reason, your employer didn't do that final annual adjustment.
But if you opted out of withholding?
Right. If you qualified for and chose the exclusion from monthly withholding and your total annual dependent work income stayed below the annual limit, around $736,800 for 2024, you typically don't need to file a return unless you think you're owed a refund, perhaps because of the rental credit or other deductions not fully accounted for. Independent workers also usually file an annual return to declare their income and settle their tax.
Okay, that's a lot on IRPF. Let's quickly cover the other related tax, IAS. What's that one about?
IAS stands for Impuesto de Asistencia a la Seguridad the Social Security Assistance Tax. It's also an annual personal direct tax. But this one applies specifically to income from pensions, retirements, jubilaciones, and similarly passive benefits paid out by Uruguayan Social Security institutions.
Who pays ISS? Only residents.
It applies to both residents and non-residents as long as the pension or benefit is paid by a Uruguayan institution like BPS or one of the professional cajas.
Can recognized concubinos file ISS jointly as a family nucleus, like with IRPF?
No, that's a key difference. The family nucleus option is strictly for IRPF Category 2 work income. It's not available for ISS.
Any other big differences from IRPF?
Yes, another major one. There are no deductions allowed against IS income, none at all. The tax is calculated directly on the gross taxable pension or benefit amount.
So how is ISS collected then?
It's usually handled through withholdings as well. The institutions that pay the pensions BPS, the cajas, they are legally designated as responsible substitutes. They have the responsibility to calculate and make monthly ISS withholdings from the benefits they pay out. And they also do an annual adjustment calculation for each beneficiary. The tax itself uses progressive rates, just like IRPF. The rates increase in brackets based on income thresholds measured in BPC. We should note the sources mentioned the rate for the second income bracket, which was 8%, is set to decrease to 6% starting January 1st, 2025.
Now, what about that tax credit for renting your home? Does that apply to people paying ISS?
Yes, it does. That's something the sources clarify. If you're an IS taxpayer and you actually have an ISS tax liability, meaning your pension income is high enough to be taxed after the minimum threshold, you can claim that same 8% tax credit for renting your permanent home. The conditions are exactly the same: written contract, landlord identified, etc.
And filing an actual IS tax return, when is that needed?
Usually, if you only get pension income from one source subject to ISS and that paying institution did the proper annual adjustment for you, you're generally not required to file a separate ISS return.
But if you have multiple pensions.
Right. If you receive ISS taxable income from multiple sources, say BPS and a professional CAJA, and your total combined pension income is above the minimum not taxable threshold, that's 150,000 UI annually, then you do need to file an ISS return. You also need to file if, for some reason, the annual adjustment wasn't done correctly by one of the payers. If you do have multiple ISS incomes over the limit, you also need to let one of the paying institutions know using a specific form, Formulario 3800, so they apply the tax correctly across your total income.
This deep dive really shows just how many layers there are to this whole framework in Uruguay. It's quite specific.
It is, and putting it in context, the comparative sources we looked at show that Uruguay isn't alone in recognizing unmarried unions legally. It's a trend happening globally and definitely across Latin America.
Places like Argentina, Chile.
Exactly. Argentina, Paraguay, Bolivia, Chile, Colombia, Peru, Ecuador. They all have legal frameworks now for recognizing these types of unions, reflecting, how society's changing.
But they don't all do it the same way, do they?
Not at all. That comparative analysis showed huge diversity. Some require a court process like Uruguay. Others might just have a registry system. Some rely purely on proving the facts of the relationship if needed.
And property rules differ.
Massively. Some systems might automatically create a community of property, like Uruguay's default, while others assume separate property unless the couple explicitly agrees otherwise.
What about inheritance rights across borders?
That's another area with big differences. Granting the surviving partner inheritance rights if there's no will, intestacy rights, that's not universal. Uruguay does it, as do Paraguay, Colombia, Bolivia, Chile, based on the sources. But others, like Argentina's basic setup, apparently don't automatically grant those rights. The partner would need to be named in a will.
That international variety sounds like it could cause headaches if couples move around or have assets in different places.
It absolutely does. This diversity creates real challenges for private international law. Trying to figure out if a union recognized in country A is valid in country B, or which country's law should apply to dividing property or inheritance or even support payments when the partners or assets cross borders. It gets very complex. Studies mentioned, like from the Hague Conference, highlight these exact problems.
So wrapping that idea up, Uruguay's system needing the judge, the specific Sociedad de Bienes rules, the pension system access, the particular inheritance rights. This is really Uruguay's specific answer within that complicated global picture.
Precisely. It's the defined legal path Uruguay offers for concubines to get formal status and access a specific bundle of rights and obligations. The aim is clearly to provide legal certainty for these relationships within Uruguay.
Okay, bringing this all back home for you, our listener, what's the big takeaway from all this detail?
I think the main thing is that Ley 18.246, plus all the related tax and Social Security rules, they create a really substantial, defined legal framework for concubinato here. It's not just an informal thing the law ignores. It's a recognized legal status with very real consequences.
And knowing the specifics, that empowers you.
Exactly. By understanding the path to getting recognized, what it means for your property, for potential inheritance, for Social Security like pensions, and how it interacts with your taxes like IRPF and ISS, knowing all that gives you clarity. And that clarity is just essential for making informed choices about how you structure your relationship legally, how you manage your shared life and assets, and how you plan for the future here in Uruguay. It's about understanding your rights, yes, but also your potential obligations under the law.
So as we finish up this deep dive, here's maybe a final thought to mull over. Building on that comparative angle and the nuances we talked about, like inheritance not being a perfect copy of marriage. Considering how much people move around these days and how diverse families look now, do you think the current legal rules for concubinato in Uruguay really strike the perfect balance? That balance between giving solid legal certainty, which is important, and truly reflecting the fluid, evolving reality of relationships and families today?
That's a complex question, a very relevant one.
Definitely something to think about. Well, we've certainly covered a lot of ground today. the judicial recognition process, the community property system, survival pensions, inheritance details, and those quite intricate tax implications for IRPF and ISS. It's been a really comprehensive look at what the legal framework for concubinato in Uruguay actually involves, based on those official sources.
It really does highlight why being informed is so important when you're building a life here.
Absolutely. And remember, if you are navigating life here, maybe considering opportunities, investments, having that clear picture of the legal and practical landscape is just invaluable. And for your real estate needs, finding properties, getting insights into the Uruguayan market, don't forget to visit realestate-uruguay.com.
Thanks for tuning in for this detailed discussion.
Thank you for listening to the Concubinato in Uruguay podcast.